Can a landlord deny an emotional support animal? Have you ever wondered if a landlord can say no to an emotional support animal? This is a common question, especially for those involved in real estate investing. Understanding the legal framework around emotional support animals is essential for both landlords and tenants. Emotional support animals, often referred to as ESAs, are not just pets. They provide necessary support for individuals with mental or emotional disabilities. Unlike service animals, ESAs do not require specific training but must be prescribed by a licensed mental health professional. Federal laws, such as the Fair Housing Act, protect individuals with disabilities from discrimination in housing. This means that tenants have the right to have their emotional support animals in their homes, even if the property has a no-pet policy. However, there are specific situations where a landlord might deny an emotional support animal. One of these is if the animal poses a direct threat to the safety or health of others. For instance, if there is documented evidence of aggressive behavior, a landlord may have grounds to refuse the ESA. Another reason could be allergies or health concerns. If accommodating the ESA would lead to significant health issues for other tenants, such as severe allergies, a landlord might be able to deny the request. This situation usually requires substantial evidence to support the claim. Physical impossibility is another factor. If the size of the animal makes it impossible to accommodate in the property, a landlord might argue for denial. This is more applicable to very large animals in small living spaces. Additionally, if a tenant's documentation for the ESA is expired or not properly issued by a licensed mental health professional, a landlord can request updated paperwork before allowing the animal. For real estate investors, it is important to be prepared for requests regarding emotional support animals. Verifying the legitimacy of the ESA letter is essential. Landlords should also assess any potential risks or logistical challenges that may arise from accommodating an ESA. Understanding landlord insurance options can also help protect against potential liabilities related to emotional support animals. This includes coverage for property damage or legal disputes that may occur. Maintaining open communication with tenants is key. Ensuring compliance with federal and state laws can help avoid legal issues. Remember, emotional support animals cannot be subject to pet deposits or fees. While landlords generally cannot deny emotional support animals, specific circumstances may allow for a denial. Being aware of these legal aspects is essential for real estate investors to maintain positive relationships with tenants and ensure compliance with the law.